except, you know, within the confines of discussing what is the proper extent of the Commerce Clause, what is the proper extent of Congress's authority to regulate a variety of topics.
Professor Claus had a question.
Anthony, Niki answered most of it, so maybe you and Niki could kind of play this team teach story. You seem to be saying, Anthony, that states, as envisioned under the Constitution, are pretty big players in the political process. The Supreme Court has made that observation before, that rather than relying on the courts, especially the Supreme Court, some instances, politics, the states resorting to the political power, the senators, the congressmen, allies in other states, that's better and more democratic than always running to the U.S. Supreme Court. Are you suggesting that if there's a failure, say, as someone might see it, that politics provides, state representation within the Congress provides an alternative to the courts as a way of smoothing out problems with individual rights, problems with state sovereignty, and that's the answer? In other words, that allows some solution inside the Constitution rather than perhaps extra constitutional suggestions that would try to say there's some other route. Is that the last route? If you can't win politically, get enough states together, get enough allies together, that's the end of it.
Well, let me supplement that comment for a second. Because in '72, when the concept of the 10th Amendment changed, we didn't have this enormous volume of money coming into the state races.
Exactly right.
Now, we could literally have a state senator, a senator from the state of Montana, elected by reason of the influence of money from outside the state. And so, are we talking about then electing state senators to protect the interests of the state or not? So, good.
Well, yeah, one of my colleagues on the faculty at the university was a classmate of mine. We were geology majors together in college, and I kind of view, generally my role is to try to understand what's going on, just as she tries to understand earthquakes and explain it to people so that they can take that information and do what they want, rather than and recognizing certainly the beauty, right, in our Constitution. But my first purpose, and this is my contribution to the panel, is trying to explain how things actually are working today and how they might work in the future, given the forces at issue. And I think, as I've expressed, my concern with the states after the 17th Amendment, and I think any state that dealt with Senator Clark is probably happy to get rid of legislative election of our senators. Yeah. States are not directly represented. They're represented in a way, as Professor Lopatch said, we the people elect them. Given that we the people are now electing the Senate, basically given national politics, the President, Congress, as well as our local, it's very important that we the people hold each level of government to task, and that's the politics. The Supreme Court certainly enforces boundaries here and there, but as I've said, the best work, the best civil liberties victories in either the Montana legislature or in Congress are when people like Niki are in there and Stewart are in there making arguments. Those are the real victories, the laws that never have to face the court.
You see, my fear is that when you're suggesting that the political process is the ultimate go-to end of things, that then suggests that people have to have sufficient faith in the political process as an alternative adjudicator to the courts if they refuse to act, if the court doesn't feel someone has standing. If all of these myriad of rules come into play to cut off access to the court, you then turn to a political remedy, a legislative remedy.
Right.
I think one of the things that we have to do, not only as attorneys, but as citizens, is realize we have a power out there in the press. I know on our case, it's Brock et al. Versus we sued our governor, our Attorney General, the Division of Securities, and the Division of our Department of Commerce. we broke this story, this case broke out of New York Investment News to 100,000 readers nationwide. And then in Utah, we have an e-filing system that goes coast to coast. So the minute I hit a brief, whether we win, lose, or draw, people are getting those arguments, and there's better attorneys, smarter attorneys out there than me that'll pick up something and be able to use it in their next case. But one of the things that I did with the judges is we had a Chief Justice in our U.S. Federal District Court that heard the case originally, and she just summarily dismissed all of the Utah constitutional claims because she knew nothing about the Utah Constitution. So when I went up to the 10th Circuit and appealed it, I specifically asked to have her disqualified from the case because of this lack of knowledge of the highest law in the state of Utah, as long as it doesn't conflict with the United States law. And she was taken off as Chief Justice. She had to write a letter of admittance to the 10th Circuit Court of Appeals, and somehow inadvertently she was taken off of that case. And so that if we continue to press these issues as attorneys and not be afraid of the judges, I mean, it has come back to bite me later on when it went back down, getting another judge, but I've had 2 federal judges recuse themselves on that case, and it went to a U.S. magistrate. But there's a lot of procedural things we can do too. Is the U.S. magistrate did the first 3 rulings he made were wrong, and so in the federal rules you can appeal it back up to a district court judge. These are just many judges in training, and I just said we're opting out of the training session, and went back. So you play hardball with the rules, both substantively and procedurally with due process, and then bring the press in on it was a really powerful thing we did. And they tried to close off oral arguments when we got to the 10th Circuit Court of Appeals.
So one key is public education.
Yes,
and
the
social media, of course, will add to that. Anthony, you had a...
Well, and Jeff, you mentioned money in politics, and that's an important issue. There are a lot more lobbyists standing between you and your government, and it's a lot harder to get access to the U.S. Supreme Court. There are a lot more judges and clerks, and it's very expensive to vindicate your rights. It's a lot easier. The other thing why the states are better guarantors of our liberty is because they're a lot closer to us. They're a lot more accessible. There are many fewer factions, in Madison's terms, special interests, as Jeff pointed to, between us and our local representatives. And whether it's Congress or the Supreme Court, they are a long way off and don't have the same sympathy necessarily to our liberties as Montanans as we Montanans do. And that's my point in faith in politics.
So, Professor Johnstone, would you yield to Delegate Riker, please?
The Citizens United case just disturbs us terribly. And we've heard that nationally, we the people, from all walks of life, from all political parties, majority disapprove of the Citizens United. And what you're saying about the power of the Senate, well, if our senatorial candidates all over the country are controlled by these corporations who can just spend money without any limit, what hope do we have? Why? And we had a law in the books years ago about Montana. We didn't have to worry about corporations behaving as people with these elections. What have we lost, and how can we get it back?
And that's an existential question. You've been very patient. I want to turn to him. Yeah.
My name is Bob Fanning, and I'm running for governor. I had asked Stewart to be run for Attorney General, and there was another Rhodes by the name of Clinton, who is the lawyer that's bringing the Montana.
Well, turn him down.
Don't turn me down. I got to change my cologne. But I had asked them both because they do stand for something I stand for, which is the breaking the flawed paradigm that the sovereign immunity clause trumps the 10th Amendment. We have to do something about that, and it has to, and dual sovereignty.
You mean the supremacy clause?
The supremacy clause over the 10th. Did I say something else?
Yeah.
Okay. Sorry. So the supremacy clause, it is since 1972, when the Bretton Woods Agreement was broken by Mr. Nixon, we had a change in the whole economic sphere where the federal government was given unlimited resources with the printing press in order to buy policy. And now we have a unique opportunity in American history where the governor in answer to what do we do, the governor has to take a leadership role and say that the 10th Amendment was not trumped or annulled in 1865, but instead the government can take the bully pulpit and bring the natural friction of leadership in defense of the people, in that natural friction to break the broad paradigm of the Supremacy Clause and the Commerce Clause being the dictatorial powers that will hold us prisoner to these corporations, this corporate fascism, because the Supreme Court does make errors. It did allow slavery. They do allow corporate fascism, and it is the governor's job to stand up and nullify when those moments arise and take a leadership role for each and every state. When the governors talk back, that's the way the framers wanted it.
I just want to follow up real quick on what she said, when you said also, and kind of go together, is that look at Dred Scott. He said, look at Korematsu, the internment of Japanese Americans, a complete failure of the Supreme Court. And you just talked about another one. And so what do you do when you have this kind of corporate, whether it's the military-industrial complex or the military-prison complex or prison-industrial complex, that's the breakdown in politics. And so when you have that kind of breakdown, I mean, look at Montana. We have resolution initiative. Why? Because you had a legislature controlled by big business in the state, the Anaconda Mining Company and all the rest of them. That's why they did that. And so the people of Montana just spoke in referendum or initiative, referendum for medical marijuana under that populist check on a corporate-controlled legislature. But because the legislature in Congress is controlled by the same corporations in the prison-industrial complex, what do you get? It's a farce. It's a joke. Anyway.
Andy, sir.
Just to further stir the pot here, I'd suggest in answer to the question, what do we do? We shouldn't underestimate the possibility of constitutional crisis as a provocateur of change, for better or worse necessarily. And so I hypothetically pose this one. In Article 6, Section 13, subsection 2 of our Montana Constitution, it says the militia forces of the state shall consist of all able-bodied citizens of the state. And in the preceding section says the governor can call them. So I would suggest, for example, in defense of Montana's medical marijuana law, which I think passed over 70% of the populace, citizens voting for it, that the next time the federal agents go to raid a clinic, that the governor could call out all able-bodied citizens to surround that clinic in a nonviolent, unarmed way to protect the inhabitants, to enforce Montana law, and let's see what the press does with it when the governor, or the president decides either to nationalize or not nationalize that quote-unquote militia.
I would just comment that I think that that's a mischaracterization of what it would mean to enforce Montana law in that situation. Enforcing Montana law in the situation in the context of medical marijuana is to say that no county attorney, no county sheriff, no local police officer, no state district court in this state is going to prosecute, penalize, imprison a Montanan for using medical marijuana in compliance with the State Medical Marijuana Act. That's what it means for us to enforce state law. Now, if we want to talk about using state resources to undermine the federal